Counselor, whenever a prosecutor offers your client use immunity, turn it down. Use immunity is an illusion, a fraud, a scam. Consider this. If your client has been indicted, he or she has a 98% chance of pleading guilty. Even if your client goes to trial, he or she has about a 70% chance of being found guilty. Few defendants testify, so only a very small fraction of the 60,000 or so people indicted each year by the feds are going to face the possibility of being confronted with the statement they made to the prosecutor. So what's your point, John? If your client is going to speak to a prosecutor and is not going to incriminate themselves, they don't need immunity. It offers them no protection. If their statement leads to incriminating evidence, use immunity won't prohibit the prosecutor from using any derivative evidence the government discovers. If it turns out your client's statement was false, use immunity does not protect your client. The prosecutor can still use the statement to charge your client with a 1001 violation. And if your client goes to trial, it can still be used to impeach your client if he or she takes the stand to testify. Whoa! Even if there's only a 2% chance my client will go to trial, and by the way, I take my cases to trial a lot more often than that, and I win more than 30% of the time. If my client does not get use immunity, the prosecutor could use my client's statement as substantive evidence against him. You're right, if this was 44 years ago. But prosecutors have taken a page out of 1984 and present defendants with a proffer letter that says, 1. The defendant's statement will not be used against the defendant at trial or sentencing. But if the defense makes any argument or presents any evidence, the government can use their statement to rebut that evidence or argument at any stage of the criminal prosecution. So, if you make an opening statement and explain why the government's evidence will not prove your client guilty, the statement comes in. If you cross-examine the government's witnesses, the statement comes in. Present a defense case, forget about it. What should you do? Just say no to immunity. And if your client goes to trial, in opening, tell the jury that your client cooperated with prosecutors and gave them a statement, if the court allows you to. Confront agents on cross-examination with the fact that your client cooperated and even spoke to the prosecutors. And if your client testifies and the prosecutor tries to impeach them, have your client testify that they voluntarily spoke to the prosecutors, they refused immunity, and they told them the same statement they're making in court today. There is only one surefire way to protect your client if there is any possibility that your client might go to trial. Refuse immunity and state that the proffer will be pursuant to Rule 11. A statement made pursuant to Rule 11 is protected by Federal Rule of Evidence 410. Federal Rule of Evidence 410 prohibits the government from using any statement your client has made during plea discussions that did not result in a guilty plea or they resulted in a later withdrawn guilty plea. Complete, unambiguous, bulletproof protection for your client. Don't assume the prosecutor will refuse. Sometimes they agree if they need your client bad enough. What if they don't? If you think you're going to trial, decline immunity. If you think your client is going to plead, decline immunity and have your client spill the beans. Either way, your client will be better off. The position I advance in this video is based on 3 assumptions. First, that you are certain your client is just a witness. If so, your client doesn't need immunity unless it makes him feel better. 2, that you are certain your client is going to plead guilty no matter what. If so, you still don't need immunity. That you are certain your client is going to go to trial no matter what, in which case your client is far better off without immunity. For a comprehensive, scholarly, and most importantly, practical discussion of how to effectively represent a client at a proffer session, please read Ingrid Martin and Michael DeStefano, A Survey of Federal Proffer Agreements, The Shortcomings and Pitfalls in the Government's Promised Protections. The Champion, September-October 2020. My name is John May. I practice federal criminal defense. I regularly advise lawyers around the country on issues having to do with their representation of men and women under investigation or being prosecuted by the federal government. I am the author of Who Says You Can't? Strategies and Tactics for Becoming a More Creative Criminal Defense Lawyer. Now available from the National Association of Criminal Defense Lawyers, www.nacdl.org/whosays. Learn more about my practice at johnmaycriminaldefense.com.